But of course the underlying assumption of the new despotism will not for a moment hold water. Let it be granted for the sake of the argument that it is really necessary or desirable for Parliament to exhibit or to attempt the many-sided activity which is put forward as a pretext. Let it be granted for the sake of the argument that legislation of the kind would be vastly more cumbrous if recourse were not had to the contrivance of making rules and regulations in matters of detail. Yet the consequences which are here complained of are by no means necessary. Why should the rules and regulations be made behind the back of Parliament? Why, being so made, should they beg the question of ultravirus by taking to themselves the force of the statute itself? And why should the whole scheme and system be so contrived as to oust the superintendence and jurisdiction of the courts? The complaint is not that rules and regulations are made, though they are made, to be sure, in the most embarrassing multiplicity. The complaint is that they are made at such a stage, in such a form, and in such circumstances as to deprive, at one and the same time, both Parliament and the law courts of any real authority in relation to them. The citizen is delivered over to the department becomes judge in its own cause, and the measure which produces these results is itself the handiwork of the department. More than that, the method is not occasional nor sporadic, it has become quite systematic. The conclusion is irresistible that it is manifestly the offspring of a well thought-out plan, the object and the effect of which are to clothe the department with despotic powers. Those who favour or defend the accumulation of despotic power in the hands of anonymous officials sometimes suggest the question whether what is really desired by their opponents is that there should be an endless stream of litigation. The question, of course, lacks honesty. It implies, without having the courage to allege, that the aim of the despot in arrogating to himself despotic powers is to save the citizen the burden and the expense of lawsuits. A person who was willing to believe that would be willing to believe anything. No, what is desired is not that there should be endless litigation, but rather that litigation should be rendered as a rule unnecessary by the diffused and conscious knowledge that, in case of need, recourse might be had to an impartial public tribunal, governed by precedent and itself liable to review. Nobody outside Bedlam supposes that the reason why courts of law exist in a civilized community is that the founders of the state have believed happiness to consist in the greatest possible amount of litigation among the greatest possible number of citizens. The real triumph of courts of law is when the universal knowledge of their existence and universal faith in their justice reduce to a minimum the number of those who are willing so to behave as to expose themselves to their jurisdiction. It is not the individual case that matters. If a person turns any day from the Strand into the Royal Courts of Justice, he may find in one court a trial about libel, in another a trial about a partnership, in a third a trial about the sale of goods, and in a fourth, with tolerable certainty, a trial about a collision between two stationary motor cars. If he thinks of the individual case and the individual case alone, he may hastily conclude that a sad waste of time and of money is going on. But upon further reflection it may occur to him that what is really of value, and of inestimable value, is the public and permanent spectacle, which shows that if contracts are broken, damages must be paid, if torts are committed, unpleasant consequences follow, and if crimes are perpetrated, punishment must be suffered, with the total result that in general contracts are not broken, torts are not committed, and crimes are not perpetrated. It is really a vast system of public insurance. The knowledge that the machinery exists, and that when it is employed with skill and without favour, has the effect of rendering its employment unnecessary, save only in the exceptional case. To apply reflections of this kind to the present matter, it is obvious that the critics of departmental despotism desire, not litigation, but that fairness of decision which, while it renders litigation in general unnecessary, is enormously encouraged and fostered by the prevailing knowledge that, in case of need, there is a law court in the background. It is not in the smallest degree desired that the departmental decisions, when they are given, should be of such a kind as to call for review and correction by a court of law. On the contrary, what is desired is the exact opposite, but the best way of securing that result is to provide that the decision which is taken may, if the party aggrieved be so minded, be brought before the courts in the ordinary way. Or rather, to be more accurate, it is necessary that there should not be a statutory provision which deprives the aggrieved party of that remedy. The same conclusion is reached if the matter is considered from the point of view not of the citizen but of the department. One has to contemplate a case where some comprehensive scheme or programme is being carried out, under which the rights of particular individuals are, or may be, seriously affected. The statute provides that, if questions of a certain kind arise, the decision is to rest with the minister, that is, with some official in a particular department. What is likely to be the effect, in the long run, upon the mind of that official if he knows beforehand that any decision which he may give, however unreasonable it may be, and however little capable of being coordinated with other decisions given in a similar way, cannot in any circumstances be questioned before a court? Nobody imagines that he approaches the task with a conscious intention of doing injustice, but it is tolerably obvious that in such a case different considerations may apply from those which would naturally lead up to an extremely careful and well-considered system where every decision was made with the knowledge that at any moment both it and the rest might have to be explained and defended in public before an impartial investigator. Nor should at least two other considerations be overlooked. The first is that, as things stand, the official charged with the final and unimpeachable right of giving the decision is to all intents and purposes the other party to the controversy. The scheme is really ludicrous. One of the parties is absent, there is no hearing, the decision is given by the opposite party, and there is no appeal. It is certainly a simple and expeditious way of disposing of controversial questions, but it is hardly likely to bring into existence a body of case law that would stand examination. The other consideration, and it is fundamental, is that this invidious task, this almost impossible duty of doubling the parts of suitor and judge in the absence of the other party, is not something which is thrust from outside upon a body of reluctant officials. No, it is they who seek it is they who ask for it, and it is they who contrive it. It is not that some other authority shirks and evades the duty. All others are deliberately excluded, and it is a cardinal feature of the departmental scheme, departmentally conceived and departmentally brought to birth, that the department itself should possess these despotic powers. That is a sinister fact which should never be forgotten. Government departments, as Professor Morgan writes in the course of his excellent volume Remedies Against the Crown, are too much inclined to attribute the same sort of mystical efficacy to acts done in virtue of statutory powers as in earlier times they were wont to ascribe to acts invoking the prerogative, and to contend that the mere fact of those acts requiring confirmation by Parliament is sufficient to invest them with a kind of sanctity which puts such acts, even when inchoate, beyond the reach of the law. Where the courts can intervene, they do so, but the remedy lies to a large extent with public opinion as expressed through its representatives in Parliament. The parliamentary draftsman's language should be carefully scrutinised by members of Parliament in committee before they allow legislative measures, delegating large powers to government departments to be placed on the statute book. Some highly significant remarks were made at the Royal Academy banquet on May 4, 1929, by Lord Salisbury, in his reply to the toast of His Majesty's ministers. He said, see The Times, May 6, 1929, that, quote, "Not merely His Majesty's present ministers, but His Majesty's government as an institution was the coping stone of the constitution of this country. Nothing was more clear than that, whatever party was concerned, the government was growing in importance every day. The government was absorbing more and more of the power which used to belong to Parliament. Those who were familiar with public affairs had seen the difficulty under which Parliament itself was conducted, and how the power in the state was concentrated in the government. In regard to the House of Commons, matters had undoubtedly been carried to such a point that complete freedom of speech did not seem to be any longer possible, and a good many details as to important measures could never be discussed there. When they came to the House of Lords, measures reached them so late that there was hardly time to discuss them at all, perhaps just 3 to 4 days in which they were called upon to do their duty. Under such circumstances, the government became more and more important, and a greater and greater responsibility rested on it." End quote. A little later, speaking of the enormous increase of a minister's business during recent years, he said, quote, "There were memoranda of the Cabinet, there were the memoranda of committees, and the reports of committees and of subcommittees. Papers were mounted higher and higher, so that even if ministers had nothing else to do, it was with the greatest difficulty that they could get through the detailed business and keep their heads, as it were, above water. Therefore," he concluded, "they could not do better than give their best wishes to the government, and it did not matter whether the government of the future was Conservative, Liberal, or Labour, the same sort of difficulties would arise." End quote. The significance of this illuminating passage, it may be suggested, will hardly be impaired if, wherever in it the word government appears, the word bureaucracy is substituted for it. A correspondent of the Times, referring recently to "these days when we hear so much of political chiefs as wax in the hands of their permanent officials and of the ever-increasing power of the bureaucracy," cited a pleasant passage from Plutarch's Life of the Younger Cato, North's translation. Before taking the office of quaestor, Cato made particular inquiry what powers attached to it. Quote, "So he no sooner came to his office, but he presently made great alteration amongst the clerks and officers of the Treasury, who, having the laws and records in their hands, and exercising the office commonly under young men which were chosen treasurers, who for their ignorance and lack of experience stood rather in need of ministers to teach them than that they were able to correct others, they themselves were the officers and controlled them. But Cato, not contenting himself with the name and honour of the thing, did thoroughly understand what the clerks and registers should be, and therefore would have them to be, as they ought to be, ministers under the quaestor only. Thus, having pulled down the pride and stomach of these clerks, and brought them into reason, in short time he had all the tables and records at his commandment, and made the treasure chamber as honourable as the Senate itself." End quote. The historical parallel may be worth remembering, if in this country zealous officials should ever have the opportunity of congratulating themselves and each other that there is a weak government in office, and that therefore they can do that which seems right in their own eyes. Of all methods of administration, that is the worst, whereby real power is in the hands of one set of persons, while public responsibility belongs to another set of persons. It is a method, as all experience shows, well calculated to encourage the performance of acts which either set of persons which either set of persons, if they had both the responsibility and the power, would be astute to avoid. In the same context, reference may be made to certain remarks of Mr. Justice Eve in the City of London on the 17th of July 1929, The Times, July 18th, 1929. Quote, "To those," he said, "who were convinced that the best government was that which governed least, it was alarming to contemplate the increasing scope of legislative interference in those matters which in the past had been considered the private affairs of the citizen. Legislative interference was sometimes supported by attractive pretexts, preceded by certain harmless intrusions, and, if they were tolerated and ignored, the attack would become more aggressive, the advance more permanent and more rapid, and individual liberty and corporate activities would find themselves hampered by unnecessary restraint. The insatiable appetite to control other men's affairs was often evinced by those whose capacity to manage their own affairs was in inverse proportion to their desires." End quote. Nor do the admirers of the new despotism show much appreciation of the actual discouragement and obstacles with which its methods so frequently offer to persons engaged in the difficult daily labours of local administration. There is no need to multiply examples. One typical criticism may suffice. At a recent meeting of the Mental Hospitals Association in London, the President, Sir William Hodgson, spoke of the need of a bill to amend the existing law relating to lunacy. Quote, "Such a bill," he said, "would meet with general support if it were formed on enabling rather than compulsory lines, and did not give any powers of large control to the central government department. It was hoped that the new cabinet would realise that the spirit of local government should be protected from too much arbitrary interference by government officials, who were apt to be greedy of the power of giving instructions rather than suggestion and information." The Times, July 18th, 1929, end quote. A cognate, but quite separate matter, is the important branch of the law which has to do with the position of the Crown as litigant. So long ago as 1921, a committee, of which the present writer was chairman, was appointed to consider the matter and to propose such amendments of the law as might be thought advisable and feasible, due regard being had to the exceptional position of the Crown. In 1924, when various differences had made themselves manifest and before the drafting of a proposed bill had been completed, the original terms of reference to the committee were modified. The committee was, by the modified reference, requested to prepare a bill to give effect to certain principles on the assumption that the alterations in law involved therein were both desirable and feasible. The committee was therefore relieved, though the fact has perhaps been too little appreciated, of the duty of making any recommendation as to the desirability or feasibility of the proposals. Its task became the very different task of drafting a measure which, if it were thought that certain changes could and should be made, might give statutory effect to them. The report of the committee, including the text of a draft bill called the Crown Proceedings Bill, was presented in February 1927. The chief matters referred to may be described in three propositions, the validity of which was, for the purposes of the bill, not so much accepted as assumed. 1. That the procedure by information and petition of right should be abolished, and the procedure in cases in which the Crown is a litigant should be assimilated, as far as possible, to the procedure regulating the conduct of cases between subjects, including such matters as discovery, the receiving and paying of costs by the Crown, and the like. 2. That the Crown, with certain reservations, should be placed in the same position as a subject as regards the power and liability to sue and be sued in the county courts. 3. That the Crown should become liable to be sued in tort. The draft bill still remains only a draft bill. Its merits and demerits do not call for consideration here, but if and when a serious attempt is made to transfer it to the statute book, some of its provisions will require, and will no doubt receive, careful consideration, including provisions which might have the effect of enabling a government department to mix itself up in litigation at its own will and pleasure, freed from any check or control on the part of the law officers of the Crown or the Treasury Solicitor. End of Chapter 8.